Most of us carry a quiet assumption: the Constitution locked in 9 Supreme Court justices. It's written down somewhere in that solemn document with the big signatures. That must be where the number came from. That must be where it has to stay. It's a reasonable assumption, and it's wrong. The Constitution, as it was written in 1787, says almost nothing about how many justices should sit on the Supreme Court. It creates the office. It describes the job, and then it leaves a blank. Congress had to fill that blank themselves. When the first Congress sat down to write the Judiciary Act of 1789, they faced a practical puzzle. The nation was new. The court was new. How many justices would actually be needed to do the work? They made a decision: 6, not 9. 6 seemed reasonable for a small, young nation, but 6 didn't last. In 1801, the outgoing administration dropped the number to 5, a deliberate political maneuver to limit the incoming president's power to appoint justices. That stung enough that it got reversed. By 1807, Congress raised it to 7. Then, as the nation expanded westward and the country's territory exploded, Congress realized something important. Justices weren't just judges who sat in one marble building in Washington. They rode circuits. They traveled across regional court systems, hearing cases across hundreds of miles. More territory meant more circuits to cover. More circuits meant more justices needed. In 1837, Congress jumped the number to 9 to handle westward expansion. By the 1860s, during the Civil War, it briefly climbed to 10. Then Reconstruction politics brought it back down to 8. Each shift was tied to real governance problems, not abstract principles. Each change was a response to a working problem that needed solving. By 1869, Congress settled on 9 again, and this time 9 stuck. Why 9 endured tells us something important. An odd number prevents tie votes, a practical matter when justices have to make actual decisions. 9 was large enough to represent different regions and regional perspectives across a growing nation. It was small enough that the justices could still deliberate as a genuine body, rather than a parliament. There was a balance to it. The last serious attempt to change the number came in 1937, when Franklin D. Roosevelt, frustrated with the court's decisions, proposed adding 6 more justices. Congress rejected the idea. That defeat signaled something. The number had become settled. Not because the Constitution demanded it, but because enough people, across enough political divides, had come to accept it. And that acceptance turned into something that felt like permanence. The Supreme Court's size is not sacred text. It's a human structure that evolved in response to real pressures and real politics. Congress could change it tomorrow if they passed a law. The fact that 9 has persisted for over 150 years says something about political consensus, about how much agreement we need before we stop tinkering. But it says nothing about constitutional necessity. The Constitution left the door open. Congress walked through and made a choice. And then, for a very long time, we all forgot they had.